Okay, good morning everybody and welcome to my IVF Answers webinar platform, part of the European Fertility Society, which are dedicated to supporting, raising awareness and educating patients who are facing infertility challenges. EVS core mission is to guide and assist patients in making one of the most significant decisions of their lives, choosing the right fertility treatments and solutions, as well as asking questions in a live format. Today, we're continuing with the second session in the series of events dedicated to mitochondrial replacement therapy, or MRT. And today, we're going to discuss the regulatory landscape of mitochondrial donation, the legal considerations. So our guest speaker today is Stephen Page, LLB ONS. Welcome, Stephen. Stephen is a family law accredited specialist and a dad through known egg donation and surrogacy. He has also suffered infertility. Since 1988, he has advised in just under 2,000 surrogacy journeys for clients throughout Australia and 37 other countries. He is the principal of Page Provan Family and Fertility Lawyers in Brisbane, and he was admitted as a solicitor in 1987 and has been an accredited family law specialist since 1996. He's a fellow of the International Academy of Family Lawyers and of the Academy of Adoption and Assisted Reproduction Attorneys, and since 2012 has been an international representative on the ART Committee, Assisted Reproduction Technologies, of the American Bar Association. Stephen is a board member of the Fertility Society of Australia and New Zealand. He's author of When Not If, Reproductive Treatment and Law for the American Bar Association. Stephen was the inaugural Pride in Law Award recipient 2020, and in 2023 received the Queensland Law Society Presidential Medal. And I had the honour of having a look at your CV, Stephen, which at 42 pages was fairly amazing. And you told me that this is your 303rd presentation.
Well, I'm a lawyer. I'm not so good on maths, but yes, as best I can add it up, 303.
Perfect. Perfect. So I kind of think over to you now. And just to remind all the participants that this session is recorded and that any questions or any discussions are going to be anonymous. So I'll put your presentation up for you, Stephen, and hand over to you.
Thank you. And g'day, everyone. It's just after 8 p.m. Where I am on the other side of the world from where you are. I'm speaking, as I would say in Australia, from the Yagara and Turrbal, the lands of the Yagara and Turrbal peoples, who are the original owners. And of course, today I'm talking about, as Valerie has introduced, regulation of mitochondrial donation. And I'm focusing on two countries because I was asked to focus on two countries, that of the United Kingdom and that of Australia. So the starting point, I suppose, is to look at who regulates mitochondrial donation. Most countries ban it. For example, it's not available in the United States. The first mitochondrial donation case occurred in Mexico by a doctor from New York because it wasn't possible to do it in the United States. So he played the old game that lawyers often do, which is that of forum shopping. He went off to Mexico and did it there. And many countries have no laws, but it's not practiced. And one might think that IVF occurs everywhere, but it doesn't. There are many countries where IVF doesn't occur, but even if it does occur, it doesn't mean that mitochondrial donation is available, even with an absence of laws. As seen in the next dot point, in the jurisdiction that's only recognised by Turkey, Northern Cyprus, mitochondrial donation occurs, and that's in the vacuum where there are no laws. And so far as the UK is concerned, the UK permits it, and Australia permits research and training leading up to allowing it. So mitochondrial donation is not available in Australia currently, but the current pathway is that hopefully within the next couple of years, it will be available. The United Kingdom, the regulation of mitochondrial donation is contained under the, I must say, I thought it was only Australia that came up with these long names, Human Fertilisation, Embryology, Mitochondrial Donation Regulations 2015. And only one centre is permitted to undertake that. It has to have a licence specifically for that. and that is the Newcastle Fertility Centre. And sorry, just to go back to that, as I understand it, there's only been one child so far born in the UK through mitochondrial donation, and that was last year, or certainly the first child was born last year in the UK through mitochondrial donation. And there are two permitted techniques, and these are set out in those regulations, and these are the common techniques used for mitochondrial donation, namely maternal spindle transfer and pronuclear transfer. And you can read for yourselves what each says. And I certainly don't profess to be an expert on embryology. Valerie is much more an expert on embryology, and she is one after all. But you can see that it's quite technical, but essentially the recipient's mitochondria are removed, and then the donor's mitochondria are implanted or transferred into either the egg or the embryo. So certainly quite technical, and what's interesting from the point of view of regulation is some of the research that indicates that the whole point of doing this, of course, is to prevent mitochondrial disease from being transmitted. And one would expect, therefore, that if you remove all the mitochondria from of the recipient and instead replace it with the mitochondria, the building blocks of human energy, from the donor, that would be nice and simple. But certainly there's certainly been considerable research that indicates that there is some of the mitochondria from the recipient remaining in the cells. So it's so that's certainly a challenge in terms of both the science but also the regulation, because if we have this leakage, I suppose might be the term, or this residue remaining there, then how effective is the technique, and should the technique be allowed? In the United Kingdom, there must be a central register, and the gamete register shows that the person is a mitochondrial donor conceived person. The applicant from 16 years can request the Human Fertilisation and Embryology Authority, HFEA, to provide information. And you can see there that there are screening tests carried out on the mitochondrial donor and their personal family history. And the description of the mitochondrial donor is provided by them, and any further information that the donor provides with the intent of it being supplied to the donor-conceived person. So certainly, I think it's certainly a good idea having that central register, because that information will be available to the donor-conceived person. One of the features in recent years, in Australia at least, has been the impassioned pleas by donor-conceived people to the right to information. And that's in the context of, I suppose, what might be described as everyday gamete donation, namely egg donation, sperm donation, and also embryo donation, that the donor-conceived person can find out where they have come from and identify the donor. I think this takes it a step further because of the complexity with mitochondrial donation. And then the next question that is obviously asked, well, if you've got three people helping create this person, namely you've got the mitochondrial donor as well as the sperm from the man and eggs from the woman, is the donor a member of family? And it's quite clear from the regulations, no. There's been a line in the sand drawn in the regulations in the UK saying the donor is not, and there's no relationship. And this, of course, is in the legal sense, because if they are related, then there might be a claim on the state. There might be some obligation to pay child maintenance or child support on the way through. So It's clearly identifying that the members of family are the recipients to the donor-conceived person, but not the mitochondrial donor. And it's not just a case of turning up to the Newcastle Family Fertility Centre and saying, well, I'd like to undertake this. It's really a very complex process of being able to proceed. And HFEA approval is required. You have to identify that there's a particular risk that any egg extracted from the ovaries of the woman may have mitochondrial abnormalities caused by mitochondrial DNA. We know that mitochondrial disease has different shades. It may be severe, it may not. And of course, this is a fairly complex process. So we've then got the next requirement that there's a significant risk that a person with those abnormalities will have or develop serious mitochondrial disease. And of course, that's a medical opinion, presumably from a geneticist and from doctors. It will certainly be a collective decision with input from various professionals. And as you can see there, the first approval occurred in 2018. One would imagine that approval process would require a series of reports and then discussions around the table before there's a consensus that this matter should proceed. And having been on a national committee for an IVF clinic here in Australia dealing with surrogacy and donation, it was interesting to listen to different doctors as to their different approaches. Some were more liberal, some were more conservative. And getting the input of nurses, getting the input of embryologists and counsellors, one would imagine that the approach taken by this process, set out in regulation, will be necessarily conservative, given the nature of what's involved and how the regulations are set out. And in the I just put this slide forward so that if you want to find out further information, if this slide is available to you or this PowerPoint is available to you, you can click on the link and get that. Now, Australia has followed the United Kingdom lead, and the law here, it's an amendment to the Prohibition of Human Cloning for Reproduction Act. So when it comes to human cloning and related activities, these are either completely banned or there are some licensed activities which can be undertaken, for example, as to research, which need regulatory approval. Australia being a federation, it's remarkably complex as to how this all occurs, because, for example, with the Prohibition of Human Cloning for Reproduction Act, which requires accreditation of IVF clinics Australia-wide and then bans certain activities and permits others, it is a Commonwealth Act. In other words, it's passed by the Federal Parliament, and the Federal Parliament has limited powers. So we then find that there are matching acts passed by 7 of the 8 Australian jurisdictions, namely 6 states and 1 territory. The Australian Capital Territory is the territory that has enacted a similar law. The Northern Territory has not. Along comes Meaves Law in 2022. There was certainly discussion between the Commonwealth, the states and territories at the time. And this alone amends the Prohibition of Human Cloning for Reproduction Act, but none of the state or territory laws have been enacted. Now, there are 2 different views about how far the Commonwealth law applies. There's some view that says, well, the Commonwealth has the power to do all of these things all on its own. The more conservative approach is that it can't, and that it has limited regulatory powers and therefore has to rely on the broad regulatory powers of the states and territories. And often the states are seen as being annoying irrelevance in Australia. But certainly what we saw during the pandemic was that individual states were, by their regulations, preventing interstate travel during the pandemic. So that, for example, in one street, which the north side is in Queensland and the south side is in New South Wales, there was a physical barrier between the two. And it was very hard for New South Wales residents to get into Queensland. So the states have broad powers. Why this is relevant to mitochondrial donation is that it's only the Commonwealth law that has changed, none of the state laws. And that then sets out if there is going to be subsequent change, namely that mitochondrial donation is possible in Australia. That means that the Commonwealth of Australia has to lead, the federal government has to lead the states along and get them to agree. Because if they don't, then it won't be possible. So where we've got to, Meve's Law, and why it's called Meve's Law is because Meve was a child who was in the electorate of the then Health Minister Greg Hunt, and she had mitochondrial disease. And given that everything that she had been through and her parents had been through, he was really quite impassioned about getting this change put through so that we could have mitochondrial donation occurring in Australia. But the first step was to allow for research, and that's where Meve's Law has got to. And you can see there Greg Hunt, the then Health Minister, describing who Meve is, or at least was. I don't know if she's still alive. I'm sorry. I don't have that connection with her. But you can see she's bright, she's bubbly, but suffers from the most challenging of medical issues. And it's interesting talking to geneticists about some genetic conditions. I had always thought that cystic fibrosis was amongst the worst of inheritable conditions, but I've been put right by a geneticist who is also a paediatrician that it's not. And one of these, of course, is severe mitochondrial disease. So the pathway, the Yellow Brick Road, is this staged pathway in Australia. And Mr. Hunt was talking about 2 stages, but when I looked at the legislation, I identified, and the regulations, in effect, there are 5. And you can see there, the first one is the preclinical research and training licenses. That certainly started. Stage 2, clinical trial and research license. I believe that has commenced. Stage 3, clinical trial license. I don't know whether that has commenced yet. Stage 4 is the clinical practice research and training license. And finally, stage 5, the clinical practice license. Now, you don't get to stage 5 unless you've done stage 4, and you don't get to stage 4 unless you've done stage 3. Now, it's not just me saying that and being an obvious thing to do. That's how the legislation is written. You do not get to the next stage unless you have completed the last stage. So in late 2022, early 2023, the Australian government committed this $15 million Australian, about 10 million US, over 4 years. And the partners include, as you can see there, Monash University and Monash IVF, and thankfully Newcastle University in the UK, so that information, that knowledge that's been gained from the practice in the UK is able to be transferred to Australia. The clinical practice license, so that first step, sorry, that's the last step if I get it right, is creating an embryo using the permitted technique with the intention of minimising the risk of the embryo inheriting mitochondria that would predispose any resulting child to mitochondrial disease, and placing the embryo into the patient's body for the purpose of achieving pregnancy, and by use of genetic material from more than 2 people. There's no surprise with any of that. That's what you'd expect to see, but nevertheless, that's written into the legislation. And licensees are approved by the National Health and Medical Research Council. This is a federal government body, and it has broad remit when it comes to health and medical research. So, for example, it determines general medical research funding within Australia, but it has really a long history of regulation in this space. So in terms of talking about IVF clinics in Australia, every IVF clinic in Australia must be accredited with the Fertility Society of Australia and New Zealand, and in doing so, subject to any state or state, territory or Commonwealth law, must comply with ethical guidelines which are handed down by the National Health and Medical Research Council. And that's just one aspect. The NHMRC hands down ethical guidelines or guidelines about use on a whole variety of topics. So it's certainly quite a respected institution and very active in the space. The next statement, that licensees in effect must be constitutional corporations. This is only a technical term. In effect, if you have a company, it is a constitutional corporation, but other things can also be constitutional corporations, and I've given examples there, universities. Typically, an IVF clinic in Australia will be a constitutional corporation. It'll either be an LTD, a limited company, or a PDY Ltd, a proprietary limited company, a private company. It's very rare to find an IVF clinic that is solely owned by one practitioner, but the requirement is they must be a company. The NHMRC must set out its own ethical guidelines and then be guided by those ethical guidelines. And those ethical guidelines have been written and they're available on its website. They in turn set out strict protocols that must be complied with. And they include that there must be a particular embryologist to be nominated. And that embryologist has specific obligations. So it's not a case of, well, we could just choose any embryologist. No, it's that person there, and they've got the personal obligation to meet. It doesn't matter what they've been instructed by the clinic. They must personally do it. And trial participants or patients must be fully informed of the risks and alternatives. And it's not, I've got a one-line dot point there. The NHMRC is a much, much longer list about the issues that must be identified and addressed. And if there are any adverse events, they must be notified. And we see all of those there, or at least some of those there, for example, miscarriage or premature birth. So, of course, the point of doing that is this system working? Is there something wrong? And if there's something wrong, why? Australia, like the UK, has set up a mitochondrial donation donor register, well, at least in name, but no child has been born here. We haven't gone through the process yet of allowing mitochondrial donation to occur. So this register doesn't exist in practice yet. Unlike the UK, the limit is 18 plus. I suspect over time that will reduce to 16 plus. The standard for donor-conceived people throughout Australia to access information about their donors has been from the age of 18. But earlier this year, Assisted Reproductive Technology Acts were enacted in each of the Australian Capital Territory and Queensland for the first time, and each of them adopted the age of 16 or older, and the ACT even younger than 16, with demonstrated maturity from a counsellor. So that age of 18 may drop. And unfortunately, the related research involving human embryos regulations, which are required to set out what information any mitochondrial donor conceived person is entitled to, well, they don't set that out yet. And one would expect at some level that's understandable, because no children have been born through this process, and it's unlikely for at least a couple of years, one would think. And unlike the UK, there are 5 permitted techniques, but if you're applying for a license, you can only choose one. So one might think that if you're applying for a license and you go down the UK process, that you could apply for both a maternal spindle transfer to be licensed for that and the pronuclear transfer, but no, you can only choose one. I don't know why that policy setting was made, but nevertheless, that's what's there. And the ethical guidelines talk about clinical risks, and the NHMRC issues these ethical guidelines for the use of ART, and what's happened is that they've been added to following this Meaves law being enacted, specifically to do with mitochondrial donation. And I'll just give you a second to read that. But wait, there's more. And here is the next one: the appreciation of the risk of mortality, permanent disability, etc., for things going wrong. In other words, this is not a settled technique. There are risks in undertaking this technique. Things might get wrong, and those who are intending to go through this process need to know that to be able to give informed consent. The next requirement is that those who are dealing with patients should use clear and consistent terminology and avoid language that is potentially discriminatory or harmful, and communicate in an easy to understand way using plain language and avoiding jargon where possible. I know that can be really challenging, particularly in this highly technical place, but it was interesting to see that this is written in the ethical guidelines. This is the only place that I can identify the ethical guidelines talk about this in dealing with the use of ART in either clinical practice or research. And participants must have both genetic and fertility counselling, so you can't just do one, you've got to do both. And again, the ethical guidelines set out carefully prescribed criteria as to what is to be in each of that counselling. And there are other protections. The donor's interests are to be protected, including it's got to be non-commercial, exploitation of emotional persuasion. And I like the fact that they said, particularly if they know the trial participant or patient, so that just because someone might be a friend or family member or live in that town and be close to them, well, you've got to make sure that they're not the subject of even subtle duress. Limit the number of families, and consistent with what is seen generally in Australia, that there's no sex selection being undertaken, privacy and confidentiality to be protected, and monitoring protocols in place. There we go.
There you go. So thank you very much, Stephen, for giving us a really good comprehensive information about the regulatory landscape of mitochondrial donation. I think what struck me immediately listening to you is that where it is regulated is really, really complex, and that in other places it isn't regulated and it is just happening. So to me, that it does seem, kind of a bit of a mismatch there. So let me just...
And just on that point, I remember talking to a doctor last year from Eastern Europe who I said, mitochondrial donation, this is really interesting, but the regulations are incredibly complex, and the first child has been born in the UK. And the response was, well, in Albania, there's no regulation. There have been 40 children born so far.
Yeah.
Which is, it's great that it can be done if it can be done ethically, but what informed consent was given, what counselling was involved, there's absolutely no regulation there. So it's on the one hand, yes, it's available, but it's a bit hairy scary, I think, that there isn't any regulation and that this is just Wild West stuff.
Yeah, I think just from my reading, I think it's happening more in the space where people are using mitochondrial donation to have healthier eggs. So they rather than in the kind of genetic disease space. And I think, from the genetic disease point of view, as you said, there was the child born in Mexico, but prior to that in Mexico, they had done a triple embryo transfer the triplet pregnancy, actually it was reduced to a twin pregnancy, and those twins didn't survive because they were delivered early. So again, that lack of regulation is really dangerous. I have a question I'd just like to ask before we kind of move to the all of the audience questions. So you mentioned that the Reform Act that you've got in place in Australia at the moment, it will be robust when it's in place, apart from the kind of nuances you mentioned.
It's clearly robust now. Yeah. It seems like a complete iron wall that's been built up.
But the limitations, you were describing about embryologists being responsible and only being able to choose one
responsible.
Technique.
Yeah.
And only being able to choose one technique when actually that may not be the best one at the time. I just wondered what your opinion is of the time frame that you see this might be coming available for genetics, and then do you ever perceive it as becoming available for kind of egg quality improvement as well?
It's fun. Just dealing with the first one. Look, I think it's probably going to be a couple of years before we get through this entire process. It's designed over 4 years. That started last year, so one would hope by 2027 it's going to be in place. But let's see. I think it was interesting. Over the weekend, I was at a conference of one of the large IVF clinics in Australia, and the comment that was made on that occasion, I've heard on other occasions, was that Australian science is very innovative when it comes to this area. For example, if I've got it right, the second or third child born through IVF was in Australia. The first egg donation in the world was 40 years ago in 1983 in Australia, etc. But Australian regulation lags behind in that Australian politicians are extremely conservative. And once they lock in regulation, and often quite tight regulation, it can be very, very difficult to change that. And the comment has been made by those in the industry whom this affects that, for example, to obtain a scientific research license from the NHMRC is very, very hard to obtain because the NHMRC is very, very conservative. Mm-hmm. So we'll see. Yeah. But as the answer to your second question, I don't know. One would think so. Certainly what's been said to me is that, one of the reasons for swapping the mitochondria, to use not the best verb that I'm using, but in effect that's what's happening, has been about weight loss, encouraging higher quality embryos. I don't see that happening anytime here soon, but let's see. There's currently, I'm the, as you mentioned before, I'm a director of the Fertility Society of Australia and New Zealand. Somehow I foolishly agreed to be the secretary to the job that no one wants recently. And the Society commissioned Greg Hunt, who is now the former Health Minister, who's no longer in Parliament, and Professor Rachel Swift, to undertake a review of Australian laws regulating the industry. They've identified about 40 laws. I've identified about 70 plus, because Australia has a population of 27 million, but somehow has 9 jurisdictions. The Commonwealth, which has not much, but some laws in this place, including about this topic. But each of the states and 2 territories have differing laws. So we have this mishmash, and they have called for one uniform fertility law Australia-wide. The UK is lucky that it has such uniformity in that space, which we just simply don't have in Australia, which makes it very, very complex to change things. And sometimes they seem to change according to the electoral cycle, which of course varies from state to state.
Okay, yeah, so very complicated landscape. And I think, looking at the UK model, as you said, where it is regulated, but each family for the genetic, if there's genetic condition, I think since I think there's 32 patients that have been approved to have the treatment at the moment. And their data, as you said, they say between 1 and 4 babies, because they're worried about the anonymity of the children that have been born. But hopefully that data will become available in the future. Just moving to our questions from the attendees, we have a question from Gabriella, who's really asking kind of about success rates, I think, for mitochondrial donation, and about the genetics, which I think you did explain quite that that asking, is the child would it be from me and my husband, which you explained with either of the methods used, because actually you're just using the DNA from the egg, that would be the case. So really, to answer that question, because it's not really a regulatory question, it's more embryology, so I'm probably better placed. So, just to Gabriella, to say that, about the mitochondrial DNA, so the DNA in the mitochondria is about 0.1% of our DNA, and that DNA is involved in the energy. It's like the batteries of our cells, so it doesn't really impact kind of physical, cognitive or behavioural characteristics. So, if that kind of hopefully answered your question there, and I don't know, Stephen, if you've got anything to add.
Yeah, I would, and obviously I'm a lawyer, so I'm not going to start talking about success rates.
Yeah.
I can talk about regulation. It seems to be something that takes up a lot of my time. But I will say this. Recently, I was present when the Assisted Reproductive Technology Bill was enacted in Queensland. And as you've already heard, I'm a dad through known egg donation and surrogacy, all of which happened in Queensland. But sitting in the public gallery with me were parents of donor-conceived people and some donor-conceived people. And many of them were greatly pained that because of settings that had occurred in the past in Australia, so not recently, but in the past, that for the sake of their children, that the children did not know where they'd come from, and for some of these donor-conceived people, that they did not know where they come from donors. So they were very, very powerful advocates that they be informed, that they know where they come from. When the bill passed the House, and it did so without much fanfare. There were certainly a few speeches, all in support on both sides of Parliament. There was cheering, clapping and tears in the public gallery. Had to be quietened down by the Speaker. The point is that it's highly emotional, and those who are born through this process don't have a say about how it happens. It's been said by the former Chief Justice of the Family Court of Australia that it is a fundamental human right to know where you've come from. And certainly what social scientists say is that it's much better to explain to your child about where they've come from, because the conception of each and every one of us is unique to us. Being truthful with your child, not hiding it, not being ashamed of it, but being proud that with the amazing assistance of special embryologists and doctors and other parties like the donor of the mitochondria, your child can exist and thrive. I think that's something to be proud about, and in an age-appropriate manner to tell your child.
Yeah, and I think that's been a lot of the conversation around mitochondrial donation is that's because it's the DNA that in the mitochondria is to do with kind of energy production. Is that something that the child should know? But in the HFEA model in the UK is that they wouldn't find out identifying information of the donor, but they would be able to know perhaps what an egg donor that kind of donated their mitochondria wanted them to know. So like a pen portrait of perhaps a message and things that they may want to share. But that would be down up to the mitochondrial donor to choose to do that, as well as completing consent forms, knowing that. We've got another question from Gabriella and Constantina, which are fairly similar, looking at kind of success rates for using mitochondrial donation, but I'm not clear from their questions whether this is for a genetic condition or whether I think it's from what Gabrielle is saying. She's saying that she's had IVF and it hasn't worked. Would this change their outlook and what are the success rates? Little bit off the kind of this topic of our discussion today, but I don't know, Stephen, if you have anything to add, and then I can add what I can.
Yeah, what I'd say about a 43-year-old woman whose eggs don't look like they're going to work because they've aged out. I have clients coming to me and saying, "Oh, we've got to do surrogacy." Why have we got to do surrogacy? Oh, because I haven't been able to have a child. But often what that client of mine in going off to see a fertility specialist learns is she's okay to carry. And in that circumstance, often having an egg donor, not a mitochondrial donor, but having an egg donor fixes that. Certainly what I see as an everyday event is that egg donors are available for older women, and those older women can carry. Now, they can't always carry, and they may need to undertake surrogacy, but very, very often they don't need to undertake surrogacy. They can rely on an egg donor, which is much simpler to obtain and much simpler to do in every respect, even though it's remarkably complex, but simpler than mitochondrial donation.
Yeah. I mean, I think, as well, I mean, I haven't got the kind of figures that you're looking for to hand, but I think, there isn't enough data for people that have had mitochondrial donation for kind of, because there's a genetic condition in the family. There isn't enough data, there haven't been enough children born. As you said, Stephen, there's lots of other, it's happening in other countries, it's happening. And actually, I think the previous talk to this actually did give some case studies where they had used that with some figures. And evidence, I think there was showing that, it seems to be similar to if the embryo is euploid, has the kind of chromosomally balanced, then it does seem to be that things are very similar. But I think the thing to remember, even if you look at the previous presentation, that all success rates in clinics are really clinic specific, and it's really important that people check clinic credentials. How many times have you done it? Look at a track record, because things can vary, between one clinic and another, and it's easy to perhaps put it on a website when actually might not always be what things seem. So just to err on the side of caution.
Well, just on that point, I've certainly seen a lot of material on websites by IVF clinics saying we're the greatest clinics. Adam was a boy, and you look at this and you go, yeah, but where's the data?
Yeah.
And we are lucky in Australia that we have published data both of the industry and for auditors, but also for most of our clinics. 92% of our clinics are available for patients to look at, and then able to compare success rates. And we, in fact, have on yourivfsuccess.com.au, which is a government-funded website, the success calculator, which, as I learned on the weekend, is one of the most heavily trafficked parts of that website as patients or prospective patients are looking. But just because an IVF clinic says that it's wonderful, take that with a grain of salt.
Mm-hmm.
If there's ability to obtain data that talks about that particular clinic, wherever it may be located, look at that data.
Yeah. Just reflecting on your pinch of salt comment, I actually do some work for a charity called the Progress Educational Trust, which just kind of informs and debates around genetics and fertility surrogacy. And actually we go to a kind of a fertility show, and we actually hand out sachets of salt to people as they come in, and they say, what's that for? And we say, because you need to take some of the things you're going to be told today with a pinch of salt. So, that's something that we do. So, it's just, I think it is about, just being aware of the right questions to ask and checking, rather than, because everybody, as we were discussing actually before we started, everybody wants to be hopeful about something, but it's also important to ask the right questions to have a realistic understanding of, where you could end up. We have got another question from Helen, which I'll read out. It comes in a few parts. So on international collaboration and standardization, as mitochondrial donation technologies and regulations differ internationally, do you see a need for a globally unified approach? And how might this affect cross-border fertility treatments and patient rights? And how feasible is it for the countries to align their regulatory stances on mitochondrial donation to avoid disparities in access? And could international bodies play a role in such alignment? So quite a big question.
Well, the obvious thing is, yes, it would be good to have international alignment, but let's look at where the challenges are. Let's start with something basic. If you have a donor, a gamete donor, an egg donor, sperm donor, embryo donor, does the donor conceived person, are they able to find out who the donor is? And what do we see in places like Australia? Yes, once they've turned 16 or 18, depending on how old the jurisdiction. And as we've seen in Victoria, soon to take place in Queensland and South Australia, go back, and even if the donor was anonymous, go back into the mists of time and find out who that donor is, assuming the records are there. But by comparison, look at Spain and much of Europe, where the donor is anonymous, and doctors from Spain vigorously argue that to reveal who the donor is anathema. It's the wrong thing to do. So that there are widely differing views about that aspect. Since 2011, the Hague Conference on Private International Law has looked at regularising internationally, having international convention to deal with international surrogacy arrangements. It was identified that cross-border surrogacy journeys were a major challenge. And they're a challenge for a number of reasons. The right to reproduce, as seen in the United States, for example, the potential exploitation of surrogates and children, and the inability of children to have their parentage recognised. Now, that process started in 2011. It was thought, I thought last year, that they'd got to a certain point with their experts group, which had recommended a certain course of action, and now they've been told by the council of the Hague to go back to the drawing board. So a colleague of mine told me a few years ago that that convention won't be in place until both of us are dead. Now, sadly, She died a couple of years ago. I'm in my early 60s. I hope that I'm around for a while, but it's a very, very, very slow process. And that's something that's even more vital than this in having some standardised process, because many children are being born every year around the globe and their parentage is not consistent around the world. So, yes, I think it's a great idea. Yes, it should happen. Is it going to happen anytime soon? No, I don't think so.
Thank you. Yeah, no, I agree. I mean, there is a big call for kind of looking at global donor limits rather than it being country specific as well. So we have another question from Helen about kind of future research and innovation. And she's asking about if that recent studies have shown new genes associated with mitochondrial disorders. What would be the immediate research priorities to determine the functionality and treatment of these genes? And how might advancements in mitochondrial gene editing impact the future of mitochondrial donation? Are there important regulatory or ethical concerns you anticipate with the emerging technology?
I really can only answer the last one because I'm a lawyer in private practice. So I'm not a geneticist, I'm not a researcher, I'm not even an embryologist or fertility specialist. The answer is I don't know what might be emerging. The law, as ever, lags behind what happens in society. So I think that these techniques will be identified. I think they're going to have to be identified in regulation. But if certainly the Australian experience is anything to go by, if there are a series of regulations in place and they are rigid, then that will mean that innovations that can help others will fall behind because they won't be possible under those regulations. So it's going to be that challenge of, well, what research can be done, and therefore how do the regulations affect that? Do they enable that, or do they greatly restrict that?
Yeah, and I think with any, if you're offering, even if there's a treatment available like mitochondrial donation, I think Helen, it's still so important that just because there's a fix, we don't look to why and try and improve things in a different way. As you said, looking at the potential of mitochondrial gene editing and how the genes function and they work together with the nuclear genome. I mean, I think the more knowledge we have, then the better treatments can be informed. I don't think we have any more questions, and we're again, I think they're just really questions about perhaps success rates. But I would, if you're interested in looking perhaps at the treatment options or how treatment may work for improving or altering egg quality through mitochondrial donation, then go to last week's presentation because that has quite a lot of information there that might be helpful. Is there anything else, Stephen, that you'd like to add before we close?
Look, I just think this is exciting. I think that the UN protocol on economic, scientific and cultural rights, covenant on economic, scientific and cultural rights, talks about the right to take advantage of scientific progress. That's a fundamental human right under international law. And here's an example of it, that as time goes on, these techniques are able to be identified. I think it's exciting that science is able to come up with these solutions. They're not perfect, but the fact that that prospect is there, I think is exciting. And I hope that with the adoption of this technique, that there is a reduction in serious mitochondrial disease, that children like me don't have to go through that grief, and that those who wish to take advantage of it are able to do so without too much difficulty, and then explain to their children about how they were created, and that with the benefit of this extraordinary science, the technicians and the wonderful donors, that this child was able to be created and have a healthy life as opposed to what the other prospect might have been.
Mm-hmm. Yeah, so yeah, and I think it's got to be a collaborative approach with the science, the regulation, the law, and the ethics as well. And I think the next session is kind of looking more into the ethical issues as well, discussion around that. So last week's presentation is available on the My IVF Answers YouTube channel, as this will be in a couple of days as well. So with that, I think we will have to I'd like to put your slide back. So say a big thank you to Stephen for your talk today. And, you know, on My IVF Answers, there's the opportunity to ask more questions if you need to. And I'm going to stop the recording now. So thank you very much, everybody. Bye.
Thank you, Valerie. Thank you, everyone.
Thank you.